Okay, so good afternoon, everyone. My name is Srila Roy, and for those of you who don't know me, I'm Associate Professor of Sociology at Wits University. I'm a feminist sociologist who looks at issues of gender and sexuality broadly in the Global South. And I'm hosting this webinar on behalf of a project I run at Wits called Governing Intimacies, which is essentially trying to develop new scholarship and a new generation of scholars working on gender and sexuality in Southern Africa and India. So I think it should be obvious for a lot of you why we're having this quite urgent conversation. The conversation takes place in the light of a judgment that was passed recently, which effectively acquitted an accused of rape on the basis of consensual foreplay, and it's been termed the Foreplay Judgment. I'm not going to say much because obviously part of the plan is to unpack this, because I think perhaps like some of you, I was feeling, is this this classic instance of the law not being adequate, the law ultimately failing to do what we always wanted to do in terms of serving gender justice. And then there were various other conversations which said, no, it wasn't the law, it was an interpretation of the law. But partly why I thought it was important to have these fantastic speakers that I've got under very short notice, and I'm so grateful, is also maybe to help us push beyond that and to think of categories like consent, like intentionality, and think of whether they can actually do the work that we want them to do. And before I introduce the three of them to you, I just want to do a shout out to Loyiso Coko, who's done the admin support and is always fantastic, and Pumi, who is behind the scenes but has also been fantastic, my former colleague at Wits, and has also helped talk me through a lot of what's been transpiring. So I'm going to introduce our speakers to you in the order in which they will speak for no more than 10 minutes, and then hopefully we'll just open up to your questions, comments, and you can keep them coming by using the Q&A or the chat function. Okay, so our first speaker is Refiwe Lidwaba, who is at Lawyers Against Abuse, which she joined in October 2020. She holds an LLB degree from the University of Limpopo, and before being at Lawyers Against Abuse, Refiwe worked with Lawyers for Human Rights with a focus on refugees and asylum seekers. And she's also done a lot of work with the legal subdivision, monitoring the implementation of the Domestic Violence Act and the Protection from Harassment Act. And Refiwe, maybe you'll also tell us a little bit about Lawyers Against Abuse's work as and when you get the chance to. And really, thank you so much. I know you were on leave last week. I am so grateful that you've made the headspace for this. After Refiwe, we have Bronwyn Pithey, who's an admitted advocate in the High Court of South Africa, working for the Women's Legal Center. Whew, Bronwyn, your bio. So I'll just read a little bits of it and people can. Bronwyn leads the Right to be Free from Violence program, and is involved in several constitutional litigation cases, challenging the constitutionality of legislation, implementation of judgment laws, and access to justice for marginalized and vulnerable women. Who better to take us through what's just happened and all of our feelings around it. So thank you, Bronwyn. And finally, we have Sheena Swimmer, who's the head of the Gender Justice Program at the Center for Applied Legal Studies, CALS at Wits, which a lot of you know of. And Sheena is also an admitted attorney and litigates in the field of gender and violence, and is also doing a PhD, which is looking at gosh, I have to have a whole separate conversation with you about that, looking at the inclusion of companion animals in South African domestic violence law. How very interesting and important. So thank you, Sheena. I think a lot of people read your Daily Maverick piece, and which has also served as part of our unpacking and learning around this moment. Okay, over to you, Refiwe.
Thank you, Srila. Thanks for the invitation, and thanks everyone for joining us. My name is Refiwe Lidwaba, as Srila has already stated, and I am working for Lawyers Against Abuse, which is an organization based in Diepsloot, and we have another office in Orange Farm. So what Lawyers Against Abuse does is to provide a holistic support, an integrated support to the victims of gender-based violence in the communities where we are based. We provide both legal support, which includes assisting and accompanying the victims of gender-based violence to police stations, to open cases, accompanying them to courts when they go for pre-trial consultations with the prosecutors. When they go to court for trial, we make sure that we follow up with the investigating officers as well, just to find out what is the progress of the case, and ensuring that the victims are always kept abreast of what's happening with their cases. And then we also have psychosocial unit, which provides counseling to the victims of gender-based violence, both minors and adults. And we have a drama therapist and a social worker who are providing different counseling and therapeutic support to the victims of gender-based violence. We also have a technical support unit where, because now we cannot provide the holistic support, the integrated support to people who are outside Deep Sloot or Orange Farm. So what we do is to provide legal advice and legal assistance to those who are outside the communities where we operate. With this presentation today, I will be focusing on the legal consent and the criminal intent as addressed in criminal justice system pertaining to sexual violence offenses. I would firstly like to define what legal consent is and its implications. As defined right now, legal consent is consent that is given freely and voluntarily by someone who understands the nature of the act involved. And with the use of the subjective test as opposed to the objective test as it stands now in our law, it is the victim of the sexual violence offense who is put on trial and who now bears the responsibility to prove that she did not give the legal consent as defined. And now in this case, the complainant, who was the girlfriend at the time, explicitly expressed in the early stages of the relationship that she was not ready to engage in sexual intercourse. And the appellant assured her that he would not be engaging in sexual intercourse with her, which then gave her the impression that he was okay with that setup, and this assurance put the complainant at ease and in turn made her comfortable around the appellant. And I believe the court failed to appreciate the magnitude of these two elements when acquitting the appellant. The fact that she made it clear to the appellant that she was not ready to engage in sexual intercourse, and the fact that he assured her that there would not be any penetrative sexual intercourse taking place. And on the night in question, although arrangements were made between the parties to spend the night together, the complainant reiterated her position of unreadiness to engage in sexual intercourse, to which the appellant again assured would not be the case. And let us note that the appellant acknowledged this proposition in court. Another point which I feel the court disregarded, as a man who assured the complainant, even when he was taking her pants off, that he was not going to engage in sexual intercourse with her, more responsibility, and this is my view, I feel that more responsibility should have been placed on him to allow the complainant the freedom to give explicit consent, or simply kept to his promise, and instead he did the opposite. And he is now blaming his actions on the victim, who had expressed on several times that she was not ready to engage in penetrative sexual intercourse with him. He is blaming the body language of the victim, who trusted his word that he was not going to engage in penetrative sexual intercourse with her. He is blaming the unsuspecting victim, who was under the impression that he might have other plans of satisfying himself, which did not involve penal penetration, when he went all the way. So he basically sneakily went back on his word, and the court disregarded this fact. So now the question is, should the appellant's defense of tacit consent be acceptable? Well, unless, of course, we believe that the appellant did not have the legal capacity at the time prior to the commission of the offense to foresee that his conduct would result in rape, and also realized during the commission of the offense that the complainant was not comfortable with his conduct, then yes, maybe we could accept his defense. You know, a notion that I believe absolves the perpetrators of sexual violence offenses from taking the responsibility of their actions. But what I like about this judgment is that it has once again put the spotlight on the gaps in our law pertaining to sexual offenses matters, especially on the definitional element of legal consent, which I believe has been narrowed to extent that men are given too much flexibility. You know, they are given too much freedom when engaging in penetrative sexual intercourse. And unfortunately, as it stands now in our criminal justice system, the element of legal consent uses the subjective test, which now is the state of the mind of the perpetrator at the time of the commission of the crime, as opposed to the state of the mind of the victim at the time, and which is also opposed to the objective test, which is applied in other offenses. So I feel that as a form of defense, instead of putting the perpetrator of sexual violence on trial, the victim ends up being the one on trial. The victim ends up being the one who has to now prove that he did not give the consent. I've seen so many people refer to this judgment as the foreplay judgment, and I have a problem with that. I mean, the referral to this judgment as foreplay is problematic. It is misleading, since now it implies that there was an agreement between these parties to have sex. And I will explain why. I understand the meaning of foreplay to be an activity preceding the main event. And in this case, it would mean a warm-up to sex, you know, an intentional stimulation before sex. And if oral sex and the French kissing in this matter were foreplay, then they were conducted under false pretenses, you know, because the complainant was given assurance that there will not be a penetrative sexual intercourse. As a result, there cannot be an inference to foreplay. To begin with, we can't be referring to the oral sex and the kissing as foreplay. For me, I find that very misleading. I feel that we can only refer to the acts as intimate activities between the couple, unless the appellant have every intention of engaging in sexual intercourse with the complainant, even when he was uttering those words of assurance, which leads me to my second point of the presentation, the criminal content, the element of intention, particularly looking at intention as addressed in rape cases in the criminal justice system. The law defines intention as the will to commit an act or cause the result set out in the definitional elements of the crime in the knowledge of the circumstances, rendering such an act or result unlawful. Now, from the facts of this case, again, the appellant had every intention to engage in sexual intercourse with the complainant, whether the complainant was ready or not, whether the complainant wanted to or not. And even though it might not have been his purpose to rape the complainant, I feel he foresaw the implications of performing oral sex on her, an act which he followed by another act that the complainant was comfortable with, the kissing, the French kissing in this instance. And we see that there is not one point after he promised her that there would not be sexual intercourse that he asked her if she was comfortable with his subsequent conduct. Instead, he unilaterally decided to penetrate her, which I believe again proves his intention. You know, it is clear from this conduct that his goal was to engage in sexual intercourse with the complainant. However, he realized that in order to achieve this goal, the prohibited result, which is rape, would ensue. As such, he deviously engaged in oral sex and intense French kissing with intentions of enticing the complainant, the so-called foreplay, which he is now using as a ground for his defense. Furthermore, during the commission of the offense, he would stop thrusting when the complainant complained about the pain, but just continue after a while until he ejaculated. No responsibility, none whatsoever, was placed on him to have asked the complainant whether he should continue with the act or not. So in conclusion, I feel the fact that express consent can be withdrawn by tacit consent should not be acceptable in our law, especially at a time when the rape culture is so pervasive in our country, because what it does is to place the burden to prove non-consent of the victim, while the perpetrator can just rely on conduct, while he can just rely on body language, as shown in this case. And again, I feel that for the court to accept his explanation of body language, but deny her contention regarding their previous discussions on sex, the proposition that he acknowledged, for me, also leave a lot to be desired. They completely disregarded that she exhibited discomfort with his conduct when he was taking off her pyjama pants, even though she was comforted by his prior expressions that he was not going to have sex with her. And with regards to intention, I feel that the state could have done more on that. I feel they did not presented the criminal intent as much as they relied on the consent. So my take on this case is that even though the court saw that consent and intent were interrelated, but they chose to disregard them as they were presented by the complainant in this matter. I mean, I could go on and on about the court's reference to absence of threat, about the absence of force during the commission of the offense, which is another problematic view on the side of the judgment, because I mean, for years, as the activists in the GBV sector, we have been battling to change the misleading and dangerous narrative that rape can only occur in a violent, in a destructive condition or in a destructive setting. This narrative excludes the intimate partner rape, which occur within the confines of marriages. So, yeah, that is my view on consent and on intent as they relate to this case.
Thank you, Rafiya. Bronwyn?
Thanks very much, and thanks very much for the invitation and for having me as part of the webinar. Thanks, Rafiya. I think hopefully a lot of what I'm going to say will flow onto some of the things that you've outlined really well in terms of what the law says. So I'm going to, as best I can, try and divide my input into three aspects. The first aspect is that my proposition is that the judgment is wrong on the facts. The second proposition is that the judgment is wrong in law. And then the third aspect I'd look at is there room to potentially amend the law to make it more in line with what I believe should be guiding us through all of this is the constitutional principles that underline all of our law, should underline all of our law and inform our law, including the criminal law. So I'm going to assume that most people have either read the judgment or already pretty au fait with the facts of the matter. But in quite a simplistic way, in my opinion, the facts that were set out, and it's very important to always take into consideration that it was the trial court that had both the complainant and the accused before it and was best positioned to evaluate the credibility and the evidence that was presented to the court. And I think we must always keep that in mind, that the appellate court is the court that really then decides everything on paper, which loses a lot of nuance. And I think that's the world over. There's nothing unusual about that, about this jurisdiction. But I think one must always take that into consideration, that appellate courts must be very slow to overturn a judgment or a finding of a lower court for that very reason. And I think the reason I raise this is because there is some very clear evidence on the part of the complainant in this matter that she was very clear in her communication of her lack of consent to particular types of sexual activity. She was very clear that she was consenting to X, Y, and Z, but she was also very clear that she was not going to consent to A, B, and C. And, you know, we can't beat around the bush. Let's just be clear about this. She was consenting to vaginal penetration orally, and she was consenting to vaginal penetration digitally. She was consenting to kissing, but she was not consenting to vaginal penetration by a penis. And I think we have to, you know, in order to understand that there are different types of sexual activity, this is what then leads into a finding by the court, or first not a finding by the court, but an explanation by the court, and which is true, that consent must be established at every step of the way. This is not a situation, and I don't believe, and I think that the judges, it's my one defense of the judges and the one defense of the judgment, is that I don't think that the judges in any way did say that once you consent to one type of sexual activity, that then means you are consenting to the whole lot. Because also I think what Refilwe referred to, and I think it's true, the notion of foreplay implies that we're going somewhere else, that we're getting ready to do something else. And I think that this is a real statement around agency and volition on the part of women, that in terms of having bodily autonomy, that women should have the right to consent to certain sexual activity, but not necessarily consent to the whole way, as a lot of people would then say, well, that's just not fair. But we'll look at that a little later. So I believe that on the facts, the complainant made it very clear that she was only consenting to certain sexual activity. And that becomes important later when we start looking at the subjective state of mind of the accused, because that is what ultimately is going to be tested. Our criminal law is very clear, and it is across the board. It is not, doesn't only pertain to sexual offenses. Somebody can only be found responsible for a criminal act if they have a guilty mind. In other words, that they were knowledgeable of the act that they were performing was unlawful. So you cannot be convicted for something if you didn't know it was not unlawful. And there are a lot of gray areas in terms of arguing that ignorance of the law is no excuse, etc. So, but generally, those are the legal concepts. So in our law, we do have this quite strange and difficult thing for people to understand, that if somebody in the context of sexual offenses genuinely believes that there was consent, even though that genuinely held belief is unreasonable, that person cannot be held responsible for the offense of rape. And that is really, to a large extent, what this judgment revolved around. What it's called is a mistaken belief in consent, and it is a defense that exists in our jurisdiction. Interestingly enough, it is a defense that has been resoundingly attacked in other jurisdictions and has been changed. And in fact, there are a number of jurisdictions, being Canada, the UK, some places in Australia, and a number of states in the UK, where there is an express piece of legislation that says the defense of mistaken belief in consent is simply not a defense. And that was really referring to my third point, where we may have to look at some legal reform. But if I then go back to my second point, so my first point is that I believe on the facts in terms of her behavior, her verbal communication around her lack of consent. And then in paragraph 23, if you want to go and look at all the sub points in paragraph 23 of the judgment, it's very clear that she tried to push him away. She said no, etc. And what my concern is that there was no credibility finding against the complainant by either the trial court or by the appeal court, that the complainant lacked credibility. So in other words, her version must be believed. Yes, we now have a version on the part of the appellant which is contradictory. So it is a weighing up. And yet again, the question needs to be asked. When we have the word of a complainant against the word of an accused and we have no other evidence, why is it that we time and time again are believing the word of the accused? Why are we not believing women? And we can talk about how many cases, this was a case that actually went to trial. 93% of cases that are reported to the police either don't result in a conviction. Only 7,000 cases of 54,000 cases that are reported every year even see the inside of a courtroom. So what are we saying to the remainder of those women? 93,000 cases of sexual offences every year we're saying are not good enough to take to trial. What is the message? Bluntly, are we saying we don't believe women? It's always hidden behind, we don't have enough evidence, we don't have enough, we don't have enough to go on to secure a successful prosecution. I'm calling it as it is. The bottom line is we don't believe women. And really, okay, so there was a little bit of a tangent that I went off on, but really to get back to my second point around the state of mind of the accused, this defense of mistaken belief in consent exists, and it is a subjective test, like I said, and even though we think that subjectively held belief by the accused might be unreasonable, it is still a legitimate defense. My argument is, in this situation, is that there was not enough unpacking of the whole concept of intention. And intention, yes, I don't want to get into too much technicality, but the issue around types of intention, we have, and I'll refer to the Pistorius case where everyone became an absolute expert on dolus eventualis. Suddenly everyone's forgotten about dolus eventualis. I believe that dolus eventualis would have been applicable in this case. So dolus eventualis, very briefly, is when someone can foresee, in the context of a sexual offense, when someone can foresee the possibility that the complainant may not be consenting. Now, given the facts of this case, you have an agreement between two people who know each other. They have a previous long-term sexual relationship. This wasn't the first time they had engaged in sexual activity of this nature. There is an express agreement between the two of them that they are not going to go any further than oral and digital penetration. Then something happens where the accused, unilaterally, like Refilwe says, interprets body language as tacit consent. Now, in the context of those facts, I think that the judicial officers should really be looking at, would there not be some foreseeable possibility that consent would not be with the complainant, or the complainant was not consenting, given that context? And I believe on the basis of dolus eventualis, the conviction should have been upheld. I also think that this whole concept of mistaken belief in consent, even if we were to move to a more objective test, which some people have argued, that we do need to be careful of what tests we use, because what we're not wanting to do is talk about what the reasonable person believes. Because what the reasonable man believes, and what the reasonable woman believes, and what the reasonable community, society believes, given the levels of violence in our country, unfortunately, I think there are far too many people who believe in the myths and stereotypes that underpin the extreme levels of violence in South Africa. So I believe then that really what we should be guided by in terms of developing a test which is reflective of women's lived realities is to look at the guiding principles in the Constitution, to look at the issues of equality, to look at the issues of the right to be free from violence in Section 12, and to actually use that as our guidance, not what your average person believes. Because if we were going to go back to that, we're probably sitting, it's a miracle that we actually have an acknowledgement that rape can occur in marriage, because unfortunately, I think there are still probably the vast majority of people believe that once somebody is married, she is your property, and that's the end of the story, and that entitles you to having sex at any given time. So if you're going to have men who genuinely believe that having oral sex and digital sex then involves vaginal penetration by a penis because one thing leads to the next, then we're not going to get anywhere because we're relying on a state of mind which is based on mistaken beliefs, which are steeped in myths and stereotypes around race. Sorry, around race, around rape. So just very quickly, I know that I must wrap up. So my third point really is that, yes, I do think that there is room for some improvement on our law. I think that we do need to address this issue of defense of mistaken belief in consent. And I think that we need to understand that we need to bring some elements of an objective test, but an objective test that is informed by constitutional imperatives and the rights and understanding particularly of the levels of violence against women. I cannot believe there is a man in this country that does not know, whether he believes or not, that does not know of the levels of violence. And it cannot be an unreasonable expectation on men to establish that consent is present when they engage in sexual activity. In terms of the harm that is done, I don't believe that it's an onerous burden to place on them. And that's when we can talk, which I was going to talk a little bit about, but in terms of if the state were to prove a prima facie case of lack of evidence, that we can then move to a shift where there's an evidentiary burden that then gets placed on the accused, that he then has to show that there was some attempt on his part to establish consent, which is what a number of other jurisdictions have done. I think I'll leave it there. Hopefully I've covered enough. Thanks.
Yeah, absolutely. I think we're all feeling quite breathless. Sheena.
There we go. Thank you so much for having me. So I'm going to speak a bit more on some overarching kind of themes that came out of this, as both my colleagues really touched on the specifics of the case. If you hear barking, my dogs have found a lizard or something out there, so it's quite a fiasco. So what I'm going to do is I'm going to discuss things that I've written about and I've seen in the past that really I thought informed a lot of this, which is kind of judicial bias or judicial belief in stereotypes, which Bronwyn rightly spoke about. Cases like this bringing about important conversation, and then just reiterating her point about potential legal reform. So with regards to this specific case, for me, it really exemplified something that has already been present for a very long time. And I mean, feminists in the room, I've looked through the participants there. There are feminists who have been discussing this for many years before I even came around. And that's about rape stereotypes. And I think they've importantly highlighted something that is something we often forget, is that our judges and our magistrates are part of our communities. They are part of the people we see every day, and they're part of the people who also believe in many stereotypes. May they be again about women and rape, may they be about race or even poverty. So we sometimes assume that our judicial officers are taking a gendered lens or a constitutional lens, but often we find this isn't happening. So we actually have a reinforcement of the societal views and rape stereotypes being propped up by judicial officers and vice versa. So it really is this huge issue that is constantly reinforced, and it's been for years. So around these types of things that I say are rape stereotypes, and my colleagues have spoken about consent, they've spoken about the different perceptions that a man may have around this, is that these things have been around for a long time, and they've also been there's been attempts in our law to regulate and to deal with them. So many of you will know the case of previous sexual history, which was a huge issue in the Zuma case because it shouldn't have been brought up at all. And the court and the legislature went on to try and eradicate the use of previous sexual history, although it's still allowed and it still occurs all the time without application as the defense should do. And just as by way of example, I did a study with the Medical Research Council a couple of years ago. So I had to read through rape transcripts. And previous sexual history happens a lot in cases with children. So often to try and establish whether a child, this is the perpetrator, prosecutors will even say to the child, is this the only person who's ever inserted their penis into you? So not only is this incredibly traumatic for the child and for the person reading it, I mean, I was traumatized by this every time. It's these weird kind of approaches that we get by not only those who, I mean, we assume these kinds of things from the defense, but we get our prosecutors relying on really ridiculous, archaic narratives to try and win cases as well. So then another one that a lot of you will know of is the cautionary approach. And I think that's kind of what Bronwyn even speaks about believability. And with that, you often do get, and you got it in this case, you got the credibility where we see an individual, the victim in this case, which did seem that she was a credible witness, although it wasn't reflected on to a lot of degree. But then the judges sided with the appellant. And there is this idea around the believability of women and still this returning back to the cautionary approach, which some of you who aren't legal, it's really this thing that was a women are hysterical, we make stuff up, we're trying to get back at men, so you need to take our evidence with more or less a pinch of salt. And that was done away with, and only is still used with children, which I still think is a problem, but it exists and it is happening. And there was an interesting case, although the person who tweeted it is one of my least favorite humans, but Richard Spoor tweeted the other day, it was actually about the police. And this is kind of an exemplification of this. He said how they were dealing with a case with a woman who was raped and hijacked. And when she had gone to the police and reported it, they went to this person who raped and hijacked her. And he said it was her, he was her boyfriend and there was no rape. And then she was charged with perjury. And if there's any kind of messaging we're sending out there, it's that the police aren't going to believe you. But then our judiciary is also not going to believe you either. And that actually builds on what Bronwyn had said. And I was going to speak about that in my consequences, but it makes sense that we have first very low rates of people reporting cases, which I've spoken about in a couple of articles, with the Gauteng example being the most dire of 1 in 25. But we also have a very pathetic rate of conviction in the country. With that, and this is what I wanted to speak about, just with the overarching, is also these perceptions that Bronwyn had spoken about, is we retain these ideas of the perfect rape cases and the perfect rape victim, which very rarely exists, I can tell you, because at Culls we work with a lot of victims. And the perfect victim is not someone who was drunk, it's not someone who was high, it's not someone who is wearing, and I mean, it sounds so old, these kind of perceptions. It's not someone who was wearing something that was too revealing. It has to be the perfect victim for the NPA to then proceed with prosecuting the case. And I mean, we are trying to challenge the NPA around this, but what happens is the NPA really reinforces the rape stereotypes, because it says certain people are rapeable and certain people aren't rapeable. And when I say aren't rapeable, I mean, your cases aren't going to be those that are going to find justice. So you are rapeable insofar as this may continue happening forever, because you aren't someone who fits the perfect categorization of a rape victim, although this person hardly ever exists. So I'm sure a lot of you already know that. So kind of the consequences of that, which my colleagues have gone on to speak about, is that our prosecutors and our judges have obligations that they are not, in terms of the Constitution and in terms of many of their legislation around their work, is around uplifting, upholding the constitutional values, as well as creating a court system, a legal system, which is not traumatic for people. But even speaking about this, it is traumatizing. It is scary to think that you're going to go to court and you're not going to be believed. And you have to say, oh man, I had too many drinks that night. I'm not going to even go and try this. And that's exactly what's happening, and what these types of judgments actually reinforce is that you very well may not be believed by the judicial system. And then that becomes a woman's problem because we're not perfect victims of rape. And then just with regards to that there is this idea, and I think is that we need to see our courts, and I'll touch on it in the end, is our courts stepping up and saying to our societies, our communities, that we will not condone this type of action. We will not condone your views that if a woman is drunk, you can take advantage of her. So we at least have to have our courts trying to set this example for our society, although we have our judicial officers coming from that society. I suppose that's a quandary we're going to have to deal with, or have been dealing with for many years. And then just finally, before I end and come to some kind of ideas around legal reform, is bringing these cases and bringing this into conversation, which I think is perhaps one of the most important things that came from this case, is that there was robust discussion. And I do think we also need to reflect on the people that come into these discussions and into these platforms or these onto social media, and who come. I'm just saying, this week has been a very rough week for me because I've been mansplained how wrong I am about all my views around this by a couple of men throughout the last week and a half. So although it is an incredibly important time, and it's an incredibly important place to have us discussing in our homes, with our children, that these types of views around women are problematic, there's still the elements of feeling unsafe even around this. And I think that's just something I'm reflecting on. With regards to this, so I do think there's some educational moments that can be taken. And I know that I was startled because when I had written the piece, I had actually gone to dinner with a family member afterwards, and I had said, there's this judgment, it's really rubbish, like rubbish. It's terrible that people still, whether or not we say that this is about consent, about foreplay leading to consent, is that people still believe this. And the person said to me, oh, that's a really hard one. I could see why he thought she had said yes. And when I reflect on that, people aren't as different to perhaps our judges and our families and our communities. And these are things that we need to take up and educate people about, and educate our children about, our young children, for having healthy and safe sexual encounters in the future. This can be a talking moment, and it can be a moment where we teach people about this. And just in my final thing before just quickly reiterating Bronwyn's views on reform is, I was in court with Women's Legal on Friday around a case where a woman disclosed her rape. And the judges presiding over the case in the Cape High Court had actually said themselves, before I get flack about attacking the judiciary, they said judges and magistrates need to be better. They need to also come to the courts and use a constitutional approach, which I would argue is a feminist lens in a lot of ways, and understand the rate of GBV in our country, but also the reasons why people don't want to come forward. And when judging cases, may it be rape cases, or in this case where the Harassment Act was used as a weapon by this man to silence the woman, they need to have a very specific lens when dealing with these cases, and to not do so would actually be not applying the Constitution. As all lawyers know, we learn it in first year, the Constitution applies to every piece of law that you engage with. And this was what they reflected on, which was actually, it was more profound than anything I can say here today, is judicial officers really do need to be upholding the Constitution and using this lens. So just in closing, I agree with Bronwyn around the ideas of reform, and I do want to just re-echo the fact that in our Criminal Procedure Act and SORMA, we do have already things that, not to do with this, but we do have where you cannot use conjugal rights as a defense anymore. We do have that previous sexual history is not allowed unless there's certain criteria. But we do still see these things happening. And I think that's where the educational aspect in our society comes with the legal aspect. And law alone is never enough, because when our society holds on to rape myths and rape stereotypes, the law really means nothing. Thank you so much. And I know I went a bit over.
No, that's great, Sheena. And just to say that there are a lot of comments, less questions, but a lot of comments in the chat. I don't know if you've been seeing it in the Q&A, but I want to just say three things. Just one is with the mistaken belief. I mean, I think it's just so interesting that we still in 2021 treat men like infants. Like the idea of mistaken belief is that men don't know. So forget, like, if you just want to put aside the law and the legalities, it's like men in that situation cannot tell the difference between wanted and unwanted sex. I mean, effectively, that's what we're saying, right? So that's the one thing but Bronwyn, from what I understand, you're saying the mistaken belief clause is really the only vulnerability in the law. But otherwise, you're saying the judgment is actually flawed too, besides the law. So, but I mean, we can come to that. The other thing I wanted to say was, when Sheena said, and Lorato's, I'm sorry, I think it is Lorato's been making these comments, also agrees that how, our judicial class is part of every day. And feminist sense, and I'm thinking about the Indian feminist Nivedita Menon, who says feminist sense is not common sense. Our common sense is patriarchal. So it is no surprise that from your dinner table conversations to judges, people don't believe, or as I put in the comments, there's no consensus on what even is harm. I mean, maybe in this context, nobody even thinks that actually she was violated, precisely because she consented to X, Y, Z. And the final thing I think of, which is no surprises, is in fact, and I've been actually reading Amya Srinivasan's The Right to Sex, which I don't know if some of you have been reading, but basically she says, maybe the answer is that the law is just not the right tool. Maybe this is it, right? The law is too blunt an instrument. And obviously this is one that we've gone back and forth, and how can you just relinquish that domain? But hey, I don't know, maybe it's come to that point where, as activists, as organizers, as people actually in a terrain of very limited resources, maybe we should actually be focusing and ask on other things. Maybe we should be actually redirecting resources away from legal battles towards pedagogical community development support. Do you see what I mean? Because maybe we have to just say, actually, that's not worth it anymore, because we keep coming back here. Anyway, so those are just my thoughts. I hope you have some responses to the comments and questions that are coming. Oh, there's a great one already that I've just seen. What would a visible feminist jurisprudence in South Africa look like? What a great, broad, big question, because actually maybe that's also where we should be putting our imaginative energies towards, rather than just, anyway. So yeah, just feel free to, comment or respond to whatever, and to what each of you have said, whoever would like to go first. Refuge? I'm just saying in the order of where we started, but really all up to you. Quite a lot of comments also in the Q&A.
Let me just go through the comments because I'm using my phone. So
I'm happy to say something in between while Refuge just kind of scrolls through there, maybe some of the things that you've raised. I mean, I do think that this defense of mistaken belief, I think it does. I think it's a perfect way of saying it. It infantilizes men. But what the flip side of it is it lets them off the hook. It basically says, well, we don't expect anything more from men. And actually, we shouldn't expect anything more from men. And there's been some really good writing on this by academic scholars who have said that really, if you weigh up the harm that that sexual violence results in, it really is not the greatest expectation in the world to ask men to ascertain those levels of consent. And I think linked to that is this concept of bringing in an objective test, the dangers of bringing in an objective test or an objective element into the subjective test that we use, which I know a lot of criminal lawyers don't like, but if we are going to use some kind of element of, because the test at the end of the day is, was it reasonably possibly true, the version of the accused, which is linked then to the subjective test. But we're still using reasonableness, and whose reasonableness? Who's deciding what is reasonably possibly true? Now, I really have to be very careful about personalizing any of it, but the fact of the matter is that virtually every judge who is sitting listening to these cases is engaged or has engaged in their own sexual relationships. And they invariably personalize it. And if they're sitting in a situation where they're thinking, I'm not so sure that I ascertained and made sure that there was consent at every step of the way when I was sexually engaging with a partner, then maybe I'm as guilty as the person is sitting in front of me. And there's no ways that the vast majority of judges are going to go down there. And I know it's a very cynical view, but I do believe that this concept of bringing in what is common sense and what is objective, and these objective elements, bringing into a subjective test. And that's what worries me about getting to what guides us. And that's when I want to go back to what both Refilwe and Sheena spoke about, was our constitutional imperatives and what is guided by the Constitution. We cannot rely on the common sense of the average person, because the average person in this country is steeped in myths and stereotypes of what women, who women are, what they deserve, how they should be treated, etc., etc. There's one little point that, if you don't mind, that I could just later on. Pumla mentioned it in the comments around some of the comments that were made by the lower court, by the magistrate around the virginity. And again, actually, this is the second point of which the judges, I do think, actually made some very valid points, is that we cannot differentiate a standard that is then going to be applied to women who are so-called virgins and women who are not virgins, because, and I'm no expert on this, but I've certainly heard people say that virginity is a social construct. It is heteronormative, it is heterosexist, it is based on men and women. And this whole thing of, you know, the holding up of virginity as something that we've got to protect just reinforces the whole issue. For those of you who have studied law and academically studied it, you look back at what the origins of the word rape comes from. It comes from the word rapio, it means theft. And initially when I thought that's actually a very good description of stealing something from you as a person if you've been raped. But no, it has nothing to do with that. It has to do with you as a woman being the property of another man. And if you are raped, it is seen as the property of the man being damaged and being stolen. So that is really what we're dealing with. And those themes kind of come right the way forward. So I just think that it's useful. What Pumla raised is that at least the judges in this matter did one of two things, I think, right, in terms of not equating foreplay with consent, and then also just maybe being quite harsh around this thing of, you know, lauding virginity over and above anything else. We have to have different kind of tests. Thanks.
I also think, to come in on your comment earlier around the use of law and the use of the criminal justice system. And I do think when we see that we have an 8.3% conviction rate for rape in the country, it's not working at this point. And there have to be conversations around that, because in our country, we are a very carceral country. We do want to reduce everything to crimes and guilty. But in this sense, we have something that is so prevalent, so pervasive, but we're not even getting it right with regards to reducing it. I'm not saying we mustn't do this. I'm saying this is not even working. We're not even getting this right. We're 8-something%. And I do think that's where I say that law can't stand alone. it is these ideas of our education, it is these ideas of these conversations and those things, is that the law simply is not, it's not working. It's not working, and the process of going through it is so traumatizing that I haven't. I mean, I've been abused as a child. I still haven't gone to the police to report it because I've seen how absolutely terrible the process is. So I do take what you've said, and I do think it's incredibly important that we don't see the law and the criminal justice system as the one that's going to change this. It's not going to change it, and it's not doing a great job at it at this point in time.
Refuge?
Hi, thanks, Sheila. And from my side, like I've stated before, I feel that this judgment has again put the spotlight on the gaps in our law, on the gaps, on our perspective on what rape is, on what consent means, on what intent means, and on how to prove these elements. So I'm grateful. Well, grateful is not the great word to use in these circumstances, but the fact that this judgment has brought us together here to discuss all these gaps. For me, it's a great opportunity to see how we can improve on the law, on how we can improve on our perspective as the general community, on where the judiciary as well can improve, and also the National Prosecuting Authority when presenting these cases to the court.
And Refuge, I mean, not to put you on the spot for anyone, I just thought that question was really on point. Like, I think it's from Emma asking as a law student. I think it would be very helpful if panelists could share some advice on what could one do to ensure or contribute towards policy developments in this regard. How do we use our own position and influence as lawyers to do this? I mean, it's a big question, but it's a pointed question, right? So,
but then I believe that as lawyers, as law students, we know that when bills are created, we are given an opportunity as the society to give, to provide comment or to comment on this legislation. So I believe that as the community, as the lawyers, as the law student, it is our responsibility to follow as to when these laws are being made and how can we make the comments which will assist in developing the law in a way that will end up, will create a society which is safe for everyone, especially women and children.
Sure. Could I just comment on one of the comments that has come up a little earlier on? Boitumelo says that when laws are enacted, especially where laws are at loggerheads with cultural practices, and she gives some examples, how does the legal fraternity bridge these? And I think that's a very interesting question because it plays into what test we use when we're looking at a subjective test or an objective test in terms of intention in the mind of the accused. And there's a very interesting matter a number of years ago called State versus Jazile, which involved the concept of ukutwala. And the court was very clear then. It said that irrational beliefs does not sustain a conclusion that a perpetrator's belief was reasonable. And so although we still have a subjective test, the court in that matter, and I'm very pleased to say it was a Western Cape High Court matter, which was a very good judgment, basically said, and I think it links into some of the stuff that Sheena was talking about around when it comes from the bench, to actually say that sometimes, you know, even if the law says that your genuinely held belief, even if unreasonable, must be upheld, the courts in some cases have said no. If it is absolutely irrational, and we know it's irrational, so in other words, say something like, I believe that if I'm married to a woman, I'm entitled to have sex whenever I want to, We now know that that is contrary to the constitutional norms. Whether 90% of people in this country believe in it, it's a bit like the death penalty, really. We know that the constitutional imperatives demand otherwise. And on that basis, we can actually start challenging that. And then in relation to the question around what we can do, Rafil was right. So unfortunately, there aren't that many opportunities to engage in law reform. That's why a lot of us land up going to court. We spend a lot of funders' money on going to court and challenging the laws. And I mean, you know, organizations like the Women's Legal Center, CALS, Lawyers for Human Rights, a number of organizations, that's what we do every single day. We build cases to challenge the system that is not protecting women's rights, because unfortunately law reform takes ages. I'll give you an example. We've been litigating, as some of you know, around the recognition of Muslim women and Muslim marriages. We've been litigating since 2014, and we're still waiting for, well, we're now waiting for a judgment in the Constitutional Court. So it takes a long time to get these, you know, to get these things done. But we have to, I guess that is one methodology. And I don't believe that the law is the be all and end all by any chance. But those of us who have chosen to be part of the law, that's what we keep, you know, we'll keep fighting for.
I think just to, sorry, I was load shed there. Just to add on to what Bronwyn was saying is, and especially for those who aren't in the law, and like as Bronwyn said, we do creative lawyering, that's kind of our job. We know the law, that's kind of what we do. But I think the space for activism, for advocacy around these kinds of issues is people underestimate or sometimes underestimate how powerful women's movements are. And you look at something like the total shutdown movement, Am I Next hashtag, is that in very many ways did pressurize government to get our national action plan around GBV. It goes hand in hand with a lot of things. When people say, I will not deal with the status quo, when people hear cases like this and they say, this doesn't feel right, and I always say, if it doesn't feel right, it's probably not right, is to take to the streets, take to platforms and make your voices heard. You have a lot more power as a collective or collectives than you actually think. And I think a lot of movements have really sped up a lot of things that people have been trying to work on for years by putting pressure on all the time. So I think if you're a young lawyer, or if you're a young person and you're a woman, or you're a gender non-conforming person and you're victims of this type of thing, is you have a very important role in advocacy. Whether you've studied law or not, advocacy is definitely something that is one of the most important tools in our country.
Sure, I see there's quite a lot of questions or suggestions around specialist courts. I see that my colleague from the Western Cape, Lee, has asked about it, and there's some other people who've commented on it. I mean, just to say, for those of you who don't know, we do have specialized sexual offences courts in South Africa. There are over 100 courts that have now been established and are in the process of a technical process of what we call designation. And although I personally am a great advocate and supporter of sexual offences courts, specialised sexual offences courts, which really does require specialisation on 3 levels. We have specialised personnel, specialised services, and specialised infrastructure. Those are really the 3 components of a specialised sexual offences court, which are really, really important. The problem is that only 7,000 cases a year get to those courts, and the decision-making processes by both the police and by the National Prosecuting Authority are flawed and imbued with the myths and stereotypes that are found. The bottom line is, and there are plenty of my colleagues that are on this call know as much, and Sheena has been part of the very, very excellent study that was done on attrition rates together with Medical Research Council and a number of other colleagues and partners, really showed that the funnel goes like that. There are a number of cases that, you know, and then eventually get into court. So yes, we do need specialized courts, but what we need is a revamp of how decisions are made and the kind of pressures that are placed on prosecutors around conviction rates, because that is how they are measured. We are not going to see cases that have anything really to do, that fall outside of the stereotypical little box of the perfect rape victim, and the perfect rape accused. Because those are the difficult cases. And although, of course, the horrific cases that we do have, where we have rapes and murders of women, which are hitting unprecedented levels of brutality and violence in our country, of course we have to deal with that. But unfortunately, the vast majority of women that are being sexually violated in our country at the moment are not that small percentage. And those are the women that we really need to be looking after in a far more nuanced understanding of their experiences of violence.
I'm conscious of the time, but just very quickly, if all of you can bear with me. So Pumi has another quite direct question about the case, the relevance of the medical report on virginity to the case. And then Lerato in the Q&A has what, I feel very drawn to it because it's something that always, the stranger danger narrative, right? And I think it's so, because obviously as someone who, my work is primarily on India, and I'm always looking quite comparatively and transnationally, and I'm thinking what's unique, what's exceptional, nothing, it's the same everywhere. But what I do find unique about South Africa is that it is intimate partner violence. It's overwhelmingly intimate partner violence, which leads to femicide, which is, this is the terrain. But constantly, even in progressive media, rape almost obfuscates that in a way that we kind of fall back onto thinking, oh, this is stranger danger. I don't know if that makes sense, but I wonder if there's something about the intimacy of what occurs every day to the majority of the women here, which is just unbearable, right? And of course, again, Pumla has written about that. So that was one thing. And then Lerato, she, I don't know who you are, I'm sorry, has asked about defamation suits being used to threaten women into silence. So yeah, maybe if you respond and just some final thoughts, then and we'll wrap up. And thank you for bearing with us. Okay, more things coming in though. All right.
Could I maybe quickly just talk to that last point, and then maybe Refilwe and Sheena can speak to the other points, just because the Women's Legal Centre has been very involved in a number of matters where we are representing women who have publicly named their perpetrators, and where the perpetrators, and I will call them perpetrators, have come back with various strategies at silencing them, and have either used the Domestic Violence Act or used the Prevention from Harassment Act, or have sued for defamation, or have sought urgent interdicts in the High Court, and even in one case, not actually an urgent interdict, just a full interdict. And it really seeks to silence women. And we were fortunate enough to be joined by CALS in one of our appeals from the lower courts in the Higher Court, who brought a particular lens and understanding of the misuse of these pieces of legislation, which were essentially really crafted to protect women and are being used against women. So, we're not sure yet what the law is going to do, but our arguments very broadly are that the criminal justice system constantly and persists in failing women, and it is not surprising that they are taking to other means of looking for justice. It is also a way of women seeking solidarity and sharing their stories and finding community. And the third aspect is to warn other women of dangerous men. And, women have been doing that for centuries, millennia. And because we have new forms of being able to warn each other, we are using them. And really what we've essentially relied on is constitutional rights around the right to be free from violence, right to dignity, and certainly right to privacy, and the right to freedom of speech. So, in a nutshell, we're representing a number of these women. My colleague, Chrissy Blows, is running that part of the program and is doing an excellent job. And I think it's going to be very interesting to see how the courts are going to respond. We've had some appalling judgments in the lower courts where we've literally had one woman silenced to the point where she was literally not allowed to speak to anyone, not one other living person was she allowed to speak about her rape. irrespective of the fact that actually the issue was really around, publicly posting it on social media. That was the extremity of the order. So we're challenging them and hoping for some positive outcome. But I think it's a very important area to understand, for the courts to understand the context of violence, and that is why women are resorting to publicly naming perpetrators. I'll leave the other two aspects that you spoke about, maybe to Sheena and Refiloe to talk about.
Thank you, Bronwyn. I will answer the comment about the harsher judgments not reducing the crime against women. I believe that gender-based violence is a multifaceted violence where it's complicated and it's caused by there's a lot of reasons why the perpetrators of this violence decide to commit this violence. I mean, we've come across victims who would share with us that the perpetrator told me that I can go and open a case against him, but he is not afraid of police. So it's not only judgments that's going to reduce the crime against women. I believe that more education still needs to be done as well. Yes, that is my view on the reduction of the gender-based violence.
Cool. Yeah, so I'll just touch on the points that's around the kind of high rate of violence in the home, and then just also on petitioning the appeal of the case. Well, CALS has written to the NPA, but that's more of a act in futility because it doesn't actually help. But that is activism on our part. But it seems that there are rumors that it is going to be appealed. At least there are rumors of that. Then with regards to the kind of stranger danger and things, we see that replicated also with regards to, and we must remember in our country we have a high rate of child rape as well. And we do have this issue where we assume it is the stranger danger, which is a very common thing for children. You warn them of the guy in the ice cream van when it's actually your uncle. So exactly these types of things, it's really as acquaintance and familial rape. And an important thing of this is also considering, and my field is domestic violence, is the kind of hell that women are in their homes. It is a continuum of violence. It's the verbal abuse, it's the economic abuse, it's the psychological abuse, it's the physical abuse, and it's the sexual abuse. So you are confronted and you are destroyed every day in every single way by individuals that are supposed to love you. But because of the complexities of these kind of intimate relationships, even children and abusive parents, is that a lot of times you still love these individuals. And in a lot of cases, you're economically, you need them for economic support. So it does create a very difficult situation for victims, but specifically in South African context, where we have high rates of abuse of children in the home, but also high rates of abuse of women in the home, it becomes an even more difficult discussion around why can't you leave and things like that. But I suppose that's one for a whole nother day, around inadequacies of our shelters and everything like that. But it definitely is replicated as well with our high rates of violence and rape against our children too.
Yeah, and there's also the beginnings of another conversation, I think, in the chat around abolitionist versus carceral feminist approaches. And again, it's one that I find personally really difficult to do in the classroom, because I think, I don't know, it's just too difficult to kind of actually envision what that would look like and what that would mean in a context like this. I'm so sorry we've gone over time, but I'm really grateful that you're with us, and most of those who joined are here as well. I think I speak for everyone when I say that I learned a lot, and actually it wasn't that intimidatingly legalese as I thought it might be. So thank you for breaking down the nuts and bolts of this to us, and just everyone who came, for us to have this space to just think together and to feel our way through these issues, which we know are not going to go away anytime soon. So again, to all three of you, I know you are really busy and overwhelmed. Thank you for making the time. And to everyone who came and who are still, writing, this is going to be recorded and available on a YouTube channel. So yeah, I hope you'll come back to this. I know I will. All right, thank you so much.
Thank you very much.
Thank you so much.
All right.
Bye.